Hello everyone and welcome to the Tendercoffee with Yaroslava and Tendercoffee people, makers of the coffee. We already started. We haven't met on Tendercoffee with Yaroslava in English for a long time. No wonder, guys, no wonder. It's because I have been very busy for the last few months. However, I decided to find some time to meet with you today. On this day, I suggest you consider one of the specific topics in the public procurement, in particular the peculiarities of the application and operational and economic sanctions. Okay, let's analyze. As of today, in accordance with the Economic Code of Ukraine, the parties to the contract have the right to provide for the application of the operational and economic sanctions. Now, I suggest you consider what the necessary terms and conditions must be included in the public procurement contract if its parties want to apply it. Firstly, the public procurement contract must contain the right of the parties to apply the operational and economic sanctions. Secondly, this contract must contain the kind of the operational and economic sanctions. I want to emphasize, guys, that the types of the operational and economic sanctions can be specified in accordance with the Economic Code of Ukraine. For instance, refusal to establish the economic relations for the future with the party that violates the obligation. Moreover, the party to the contract has the right to establish in the public procurement contract other operational and economic sanctions, even if the Economic Code of Ukraine doesn't contain such sanctions. Okay, next important point. The public procurement contract must contain the procedure of applying such sanctions. I want to emphasize that the features of the application procedure can be different. It depends on what the kind of sanctions the public procurement contract contains and how the parties want to apply it. Let me show you an example. If the bidder violates the obligation of the delivery deadline, then the customer will send to this bidder a letter about the applying the operational and economic sanction against him. Okay, guys, let's continue. There are several other crucial aspects regarding the application of the operational and economic sanctions. Let me explain to you. The grounds for applying such sanctions shall be only the fact of violation and economic obligation by the other party. Next important point. The operational and economic sanctions are applied extrajudicially. However, if one of the parties doesn't agree with application of the operational and economic sanctions, then this party may appeal to the court with a claim to cancel such sanctions. Next significant point. The operational and economic sanctions may be applied simultaneously with the compensation of damages, with the collection of penalties, and with the security for the public procurement contract. So pay attention. Last but definitely not least, I want to know that the Economic Code of Ukraine will be invalid on 28 August of this year. Therefore, the questions come up. Question number 1. Will the parties have the right to apply the operational and economic sanctions if the Economic Code of Ukraine becomes invalid? To my mind, guys, yes, but only in the case if the public procurement contract was concluded before the economic court of Ukraine became invalid. Next question number 2. If the customer concludes the new public procurement contract before 28 August of this year, will the customer have the right to include in this contract the operational and economic sanctions following the economic code of Ukraine? My answer, yes, he will. Okay, guys, next crucial aspects and question number 3. What should the customer do if he wants to establish the operational and economic sanctions in the public procurement contract, but the economic code of Ukraine is already invalid? Guys, in this situation, I would like to give you my advice from my experience. In accordance with the civil code of Ukraine, if one of the parties violates the obligation, the other party has the right to refuse the obligation and to terminate the contract unilaterally. But pay attention, guys, this right must be provided in the public procurement contract. And I think these rules from Civil Code of Ukraine you can use as an analogy of the operational and economic sanctions as of today, before and after 28 August of this year, even if the economic code of Ukraine becomes invalid. And let me remind you that you can get my legal advice on this issue and other topics in the field of public procurement or in the field of public financial control if you contact me separately. And I recommend you subscribe to my pages on Facebook and join my group on Signal. It will give you the opportunity to constantly be aware that you are choosing the right direction. And guys, let me know what would you like to consider in the next hour Tendercoffee with Yaroslava in English or maybe in Ukraine. Tell me about it in the comment below this video. That's all for today. Working smart but not hard. Then there are two people. See you later.